So today our department is very happy to host the topic of planning for what if, your health, your money, and your dignity. Today's presentation will be on 3 points. One is to help everyone understand incapacity and why it matters. Number 2, explain the essential legal documents that allow someone that one trusts to step in smoothly. And number 3, give practical steps to prevent family stress, financial disruption, and unnecessary court involvement. So our presenter today, Blix, is an elder law attorney who has been practicing in Orange County since 1984. She was among the first group of attorneys in the nation to be certified as an elder law attorney by the National Elder Law Foundation in 1995. Faye is the founder, chair of the Orange County Board Association Elder Law Section, and is a fellow of the National Academy of Elder Laws and a member of the Council of Advanced Practitioners. She also served on the Governor's Alzheimer's Advisory Committee and was appointed a member of the task force to create a state plan for Alzheimer's disease for the state of California. She has served on several boards, including the Alzheimer's Association, Alzheimer's Family Service Center, and the Leadership Council of the UCI Mind. She was also awarded the Maureen Reagan Outstanding Advocate Award for the National Alzheimer's Association in May of 2005. She is a contributing author to the CEB, California Elder Law Resources, Benefits, Planning, and California Powers of Attorney and Healthcare Directive. She has been named as the Southern California Superior Lawyer, Elder Law, as well as the Best Lawyers in America, Elder Law, for many years. So please help me give a warm welcome to Faye Blix.
It's good to be with you. I see a lot of familiar faces in the audience and some new friends as well. Whenever I give a presentation, I always want to be sure that what I'm saying makes sense and that it answers some of the burning questions that you have. And while we do have quite a bit of ground to cover, I want to be sure that if you have questions along the way, that you will feel free to let me know you have a question, and I will repeat the question so everybody can hear and try to provide the answer, or at least tell you I don't know. As I say in almost all my presentations, it's not very often you get to talk to an attorney without the meter running, so I want to make sure that you get your money's worth today. What I have to talk about today isn't necessarily fun, but it is important because I think there are 2 themes that show up in my office after someone passes and the family comes in to consult. And it's either, she made it so easy for me, or why didn't she fix it? And I have an evangelistic passion that I want you all to be in the group that says, you made it so easy. Because making it easy not only is important for those you love, but it really makes a difference in how you live the rest of your lives too. And for many of you, I'll be speaking to the choir. You've already done your planning. You're just here because you're gluttons for punishment, I guess. But I want to be sure that we touch on things that matter and that make a practical difference in your life. So if I start drifting into legalese, just wave your hand and say, cut that out. We've got to have translation, okay? So why is it important that we discuss these things now? And you'll see in your handout, I have a proverb that says, fix the roof while the sun is shining. In other words, if we can start planning when we have all systems go. It makes it so much easier. I have a lot of people who come to me to do wills. Almost everybody thinks they need to do a will. But when I start saying, you know, it's probably a good idea for you to do powers of attorney as well, many of them will say, you know, that's a good idea. I'll do that when the time comes. Okay. But when the time comes, it may be too late. Because the problem is that when you lose legal ability to make your own decisions, no one can make those decisions for you unless you have given them legal authority ahead of time. And so that's why capacity matters, because as an attorney, I cannot draft documents for people who have no understanding of what it is they're signing. And even sometimes, when we have a situation where some people might have enough capacity to maybe sign a healthcare advance directive, they may not have enough capacity to sign a living trust. Because sometimes capacity is a sliding scale. It's not that it's a red line, that you're now have a capacity and now you don't. Many of us have what I call lava lamp capacity, okay? We sort of go in and out. That happens to me a lot, and I don't think I'm quite yet completely incapacitated. But it's capacity for the job. So what it takes to understand a document by like a living trust, it's more like a contract. We might have to be a little more sharp than if we're simply appointing somebody to make medical decisions. And why it's important to make these decisions now is that you have to be able to understand what you're signing. You need to be able to understand who the important players in your life are, how your decisions impact your families, and to understand if I do this, then this will happen. And so it's not really about giving up control. A lot of people are worried about doing legal planning because they're afraid that somebody is going to take over their lives. But in many ways, I'd like to shift the paradigm and say that actually legal planning is taking control, because you are saying now, while you understand who you want to be in charge, should there ever come a time when you can no longer make those decisions for yourself. And if you don't do that, probably the thing you dreaded the most might happen, and that is that maybe a family member that you wanted to make sure didn't have anything to do with your life suddenly is the person who steps forward. Or it might involve the courts. It might be more public. And so as a result, it's really important to be able to get those things in line now so you can have peace of mind and know that should incapacity occurs, you've already taken care of things. If you don't, the plan that you might have made at the last minute might not count because somebody will question that you didn't know what you were doing. And it just opens the door for conflict, where I have family members that say, well, she didn't know what she was doing. You know, why did you do documents for her? She'd been diagnosed with Alzheimer's disease. Well, a diagnosis alone is not enough, because diseases can affect different areas of the brain in different ways. So just because somebody has the diagnosis does not necessarily mean that they don't have the ability to make some decisions. But it would be better if you made some of those decisions and didn't worry that you had a diagnosis. And so today we want to spend some time just about getting our ducks in a row, what kind of plans you want to make in terms of planning for healthcare and personal decisions. making decisions about managing your money and your property, both while you're alive and after you are gone. So we start out by talking about getting our ducks in a row. And I don't know where that phrase came from, but it seems to be fairly common. And I always see these little yellow rubber duckies just lining up. But all it really means is get your act together, okay? Get organized so that if somebody were to come and have to take over, say you suddenly had a stroke, and individuals had to make decisions for you, they would be able to come into your home and have it fairly laid out for you. Now, I don't know about you, but my kitchen table isn't quite as organized as I wish it could be. But I know where to find things. Could somebody who loves me know where to find those things if they're on the third pile, 3/4 of the way down? It's not easy. And so I would suggest that you think about how you would like to find things if you suddenly had to take over for someone, and go and do thou likewise. So the first thing I recommend is having an emergency notebook. And for those of you who are more computer savvy, you might want to do your notebook online. You just have to make sure that if you do it on the computer, your computer doesn't have so many passwords and hurdles that people can't get into it. And so the emergency notebook is really just Grand Central Station for your house. That's where I would suggest you start keeping notes. And each of you will have different sections in your emergency notebook. But several things that are important would be, okay, who are the main players in your life? Who do you want called in case of an emergency? What is their relationship to you? What's their telephone number? All of their particular information. You also will want to know where your important papers are and what bank accounts are still open, what your budget is, who your doctors are, what your prescriptions are. Again, it will be different for each of you, but it will be a place that you can tell your loved ones, if anything happens to me, go to the Red Book. And just getting it done today is not enough. The Red Book is something you should update regularly. I know I'm talking to the choir. I also would encourage you, and this is not easy, but all of us tend to be hoarders. And if you suddenly had to clean out income tax boxes from 1987 forward, and you weren't sure whether it was just income taxes in those boxes, or were there some personal cards, or did somebody slip cash there, or you know what it's like when you have to clean somebody's house. Do you really want your loved ones to have to do that with your stuff? And so again, I would just encourage you, one drawer, one box at a time, start getting rid of that stuff. Get a shredder, whatever it takes, have a party with friends, celebrate a drawer at a time. But it is such a gift of love, because what I find is when family members come in to have to close up a household, either because of incapacity or because of death, to have to go through papers and stacks and drawers and cupboards and boxes and garages. It's so hard when they really want to just be with you or to be with the memories. And so I would just encourage you to put all your important legal documents in one place and to get rid of a lot of the stuff. And if there are things that are really important to you from a sentimental point of view, you can have those set aside, or these days they can be scanned so that you can have nice CDs of all of your sentimental things. Again, not anything that is rocket science or requires a lawyer to tell you what to do. I just deal with a lot of the families who have to deal with loved ones who didn't do it. And so I would just encourage you to do that. And again, it's going to be different for each one of you. You all have different lives. You have different things that matter to you. I don't care what they are, just do it. Any questions regarding organization before we move on? Okay.
How much should anyone trust the cloud in putting sections, documents up there?
Okay, the question is, how much should you trust the cloud when you put documents up there? And that's a tough one. Probably your tech club from Laguna Hills would answer that better for me than me. But I think under most circumstances, if you are very careful and talk to a registered IT person, there are good ways of being able to protect those documents. But I understand it's an important consideration. I would say they're probably as safe in the cloud as they are in your top drawer. Okay.
How far back should we hold on to taxes? 5 years?
Okay, so the question is how far back, how long do you keep documents? And you'll hear varying suggestions. Things like deeds to the house, original stocks, those kinds of things you should keep forever until you get rid of the house or the stock. Most documents, for tax purposes, it's about 7 years, and much of the documentation that you have for stock, for income taxes, can be reconstructed. And so I would say no more than 7 years, and in many cases, a couple of years is probably enough. Okay? Okay. So now let's kind of move on to making personal decisions and healthcare decisions. Right now, you have the ability to interface with your medical providers. You make your own medical decisions. But if there were a time that you didn't understand exactly what the medical person was telling you, or you weren't able to quite understand the ramifications of what your doctors were telling you, what kind of a plan do you have in place? And this is where I start getting into legalese, but if you really strip away all the legalese of most of the stuff I'm talking about this afternoon, it's that we are appointing substitute decision makers to make decisions that we want them to make and giving them guidelines. That's really all legal documents are. And so when it comes to healthcare, we are appointing someone who we call an agent to step into our shoes, to be our substitute, to make decisions for us if there were ever a time when we couldn't make those decisions for ourselves. And it involves more than just appointing that person. It's also giving them instructions. It's guidelines. Some of you will have more instructions than others. I have people who want several pages of instructions for their agents. I have other people who say, all I want my advance directive to say is, I trust my agent. She knows my values, and whatever she says goes. Okay? It's going to be different for each of you, but the whole idea is that you are saying now in advance who you want to make those decisions, what instructions you want that person to follow, and then that's not enough. How is that person going to know that you want them to be involved? And so it's not just deciding or giving instructions or getting it down in writing and setting it up so that it's notarized and officially signed. But unless the people that you have named know that you have named them, it's like if a tree falls in the forest, does it make a noise? You know, if you're not there, you don't know. So it's not just doing it, but it's communicating it. And so for healthcare, the most important legal document you should have, and I suspect almost everyone here has one, is something called an advance directive. And if you listen to those words, what that is saying is, I am directing in advance who I want to make those decisions, what I want that decision to be guided by. And I would suggest that you not just name one. In the event something happened to the person that you've named, it would be a good idea for you to name an alternate. It's up to you as to your comfort level. I have some people that have as many as 3 or 4. It's about your peace of mind. What usually doesn't work is if you name all 4 to make those decisions together. I have people who say, I don't want to hurt my kids' feelings, so I'd like all 4 of them to make decisions about my health care. And I can tell you, unless you are really unique, that's going to be a mess. Because no matter how loving and caring your kids are, or your loved ones, they usually have a different relationship with you. Even though you're their mom or your dad, they are different. They're going to have different ideas. And even if the family gets along beautifully, I can guarantee there's going to be some decision that's going to cause some conflict. And if you have to be worried about the kids fighting over you instead of the decision that needs to be made, it can be a hassle. So I'm not saying it absolutely cannot work, but under most circumstances, it's usually best to at least have one spokesperson. Doesn't mean that the others can't be involved, but there should be someone who has the final say. And in general, there are different skill sets, but the kind of person that you want to name as the agent under your healthcare power of attorney is someone who should know your value systems, know your heart, be a diplomat, not a bull in the china closet, be able to advocate strongly for your needs or your wishes without being obnoxious, and being able to get along with the rest of your family to be able to smooth the waters. Now that's quite a job description, but those are the kinds of things you're looking for. Many of you do not have children. You don't have individuals that you feel know you well enough to make those decisions. In those kinds of situations, you may want to consider looking at a private professional fiduciary who you can get to know now to become your substitute child to be able to make those decisions for you. But for the most part, the Advanced Healthcare Directive is one of the most important documents for you to have. Many of you might belong to Kaiser or HMO. Sometimes the Advanced Directive you can download from the website. So it doesn't necessarily need to require an attorney, but it should be something that states your wishes, and it's something you'll want to review. I find that my ideas about my own health care have changed from when I was 40. Okay? It's just different. And your wishes may change, but the important thing is that your agent knows your values. So if I say to my agent, I want to be able to die naturally. So if at all possible, if I have reached a stage where any kind of life support would simply prolong the moment of my death. I don't want all of those things. When I was 30 or 40, I might have wanted it all. You may still want it all, but if you do, you need to really understand the ramifications of wanting it all, and that sometimes CPR, although it works really well on television, sometimes isn't quite as successful when it happens in real life. And so in terms of the document for healthcare, it should be Advance Directive, which is the umbrella term. A power of attorney for healthcare is a type of Advance Directive. And so every hospital, doctor, nursing home, hospice who takes Medicare or Medi-Cal is required under the Patient Self-Determination Act to ask you questions when you first come. Do you have an advance directive? Okay. And at first that can be kind of off-putting. I had a person who was going in for bunion surgery, and the podiatrist's office asked if she had an advance directive. And she called the office and said, "Is there something I don't know? You know, I thought this was just a simple bunion procedure. They're talking about end-of-life things." Well, all they were doing was following through on what the Patient Self-Determination Act, and they're required to ask you about that. So it would be good for you to have the advance directive, name at least one person, and I would suggest one or two. For many of you who are married, you'll have named each other, but you tend to be about the same age, or you know, man, I'm sorry to say it, but usually the women last a little longer than you do. And so you'll want to be sure that you've got some younger people in the lineup, okay? And once you have the document, you want to make sure that everybody that you've named as an agent has a copy, your physicians have a copy, and I suggest you keep one in the glove compartment of your car and maybe upload one to your iPhone so that it's always there. For those of you who are becoming more frail, or you might have a terminal diagnosis, you'll also want to seriously consider having a POLST. And a POLST is a document that stands for Physician's Orders for Life-Sustaining Treatment. And it's a bright pink form. I suspect many of you have seen it. This is not a form that attorneys do. This is a form that your doctor and you should discuss together. And what the POLST does is it takes your advance directive and translates it into doctor's orders. So that, for instance, if you don't want CPR, your advance directive can say, "I don't want CPR." But if 911 is called and the paramedics come, they can't take time to read through 2 or 3 pages of advance directive. In fact, even if they could, they can't, because it's not a doctor's order. But if you have a POLST that has been signed by you and your doctor, and it is available when the paramedics come, and that document says no CPR, then the paramedics can honor that as a doctor's order.
Could you repeat what is POLST? Is that an acronym, or is it, and where do you get it?
Okay, so the question is, what is POLST? And POLST is an acronym, and it stands for Physician's Order for Life-Sustaining Treatment. And your physician's offices should have a copy, but if they don't, you can usually download one from the web, and many, I would suspect even, I don't know for sure, but it wouldn't surprise me if social services has some available for you there. Okay. Physician's Orders for Life-Sustaining Treatment.
The advance directive, whether it be power of attorney or a form, I sign it, Is it a legal document already?
Okay. So the question is, if I sign an advance directive, is it a legal document? And the answer is it depends, okay? And the only reason it depends is that for it to be legal, it has to be either notarized, your signature has to be notarized, or it has to be witnessed. And the witnesses cannot be your doctor or anyone who provides your health care, and should not be anybody who is likely to benefit from your early death.
And then does it need to be recorded anywhere other than in my file folder?
Okay. And the question is, okay, I've got a signed document. Does it need to be recorded anywhere? And it does not need to be recorded, but it is a document that you will want to share more freely than almost any other document, because otherwise nobody knows you have it. So that's why I'm suggesting make sure that you give a copy to everybody you've named as an agent and to your doctors. And doctors sometimes don't always get it into the file. And so what I would suggest is every time you visit your doctor's office, just ask, is my advance directive part of your medical file? And if they say no, have a copy ready, whip it out, and give it to them again.
What relation does an advance directive have with a durable power of attorney?
Okay. So the question is, what relationship does an advance directive have with a durable power of attorney? And you're about to get us into the next area, okay? So an advance directive is strictly to do with health care. An advance directive can be a durable power of attorney, because what durable means is it remains effective even if I no longer have the ability. So you can have a durable power of attorney for health care that is a type of advance directive. But I think what you're referring to is that there also is a financial document called a durable power of attorney for finances. And we'll get into that in just a minute.
Do these documents have a natural expiration date?
Okay. So the question is, do these documents have a natural expiration date? And up until 1992, they did, okay? But any advance directive that was signed after 1992 is good forever unless it says otherwise. It's just that if you're normal, probably your life has changed dramatically since 1992. And so many of the people that you have named as agents might have a different phone number, might have died, might have been diagnosed, might have dementia, there's a lot. So you'll want to review your document, not because you're worried about it expiring, but are the players still the players that you want them to be? So I recommend you keep your documents with your income tax papers, so that every year you just take a look at it and say, are these still my wishes? Are these still the players? Okay?
Advance directive and living trust, living trust. If I have a living trust, do I still need the advance directive?
Okay. So the question is, if I have a living trust, do I still need an advance directive? And the answer is, and we'll be getting into this in a lot more detail in just a few minutes, the advance directive is strictly to do with health care. Living trusts usually should not be involved with health care other than paying for health care, okay? But the person who makes your health care decisions should be authorized by your advance directive. It can still be, the agent that you name could be the same person you name as trustee of your living trust, but they wear a different cap when they're making health care decisions.
My living trust has a section about my health directive in there. That portion
Right. So what she is saying is that her living trust has a section related to health care. And I want to make sure that we don't get sidetracked here. But for the most part, if you're talking about that you got a living trust and somebody did a binder of documents for you, and one of the tabs says advance directive, that is an advance directive. If instead you're saying that there is a paragraph in my living trust that talks about my health care, then that is simply instructions to your trustee as to how to pay for your health care. Okay?
I have a medical directive. However, I want to change it a little bit or a lot. I want to be more specific.
Okay.
Do I need to redo the one I have already, get notarized? Or
Okay. So the question is, what if I want to make some changes in my advance directive? Can I just amend it? Or do I have to do a whole new one? And my advice is it would be best for you to do a whole new one. Okay. And the reason is that once a document that has been notarized, if you're making scratches and additions to that document, it could affect its validity because those scratches were not in any way notarized. So I would recommend that you just do a new one. And for one thing, it's easier when the advance directive has to be activated. If they're having to compare 3 different documents, let's see, paragraph 3.1 was interview, anyway, if you're having to sort through several iterations of amendments, it's very difficult to figure out what it is you want. So just do a new one, and it shouldn't be a big deal. You can download them. It can be witnessed instead of notarized, so your next door neighbors, as long as they're not your doctors, could witness your document. So it shouldn't be daunting. And okay, the question is, do you need both a power of attorney and an advance directive? So a power of attorney for health care and an advance directive. And under most circumstances, the answer is no, because the power of attorney is a type of advance directive. So the advance directive, if you have a power of attorney, you have an advance directive. Okay, it's a type of advance directive. So it may be called something differently, but any document that says, this is the person that I'm saying now in advance, these are my decisions, then that's what I want. Okay? So now let us just move a little more into things like money management. Okay? And just like with healthcare, it's all about you appointing a substitute decision maker. So for instance, if you were hospitalized today with some kind of mild stroke so that you couldn't sign things, who would be able to legally access your bank accounts? Okay? That's what we're talking about. So in this kind of a situation, who would you want to manage your money and your property? Not only while you have incapacity, but who would you want to deal with these things after you've died? And what instructions do you want to give that person? How will you communicate this? And so here again, and I don't mean to just be repeating myself, but you are taking control now, saying, these are the players I want. And I want to set it up so that they have the official authority. So there's no question. So I'm not left at the mercy of whoever gets to the checkbook first. But it's the person that I have named and have official authority. Now, many of you will have living trusts, okay? And living trusts are documents that allow you to put your assets into the living trust so that in the event of incapacity, the person that you've named as successor trustee can step into your shoes and continue to make decisions in the event you no longer can, or if you have died, they can follow through and make sure your final wishes are honored. The problem with a living trust is that a living trust only controls what gets into the living trust. So you can have a really nice binder that says living trust, and it's got 50 pages of beautiful legalese. But you know what? It's practically useless unless you have funded the trust. And what we mean by funding is putting your assets into the name of your trust. So for instance, if you own a condo, it may be in your name as husband and wife, joint tenants, or community property. That needs to be transferred from your names as husband and wife to your names as trustees of the trust. And that very act of transferring it to you as trustees is what we call funding the trust. And then that allows the individuals who have stepped into your shoes to be able to make decisions. Now, there are a lot of decisions that need to be made while you still are alive, but now lack capacity, that have nothing to do with your trust. For instance, signing an income tax return, calling the utility company to change the name on the utilities, trying to access IRA money. And so in those situations, a living trust will not be helpful. You need what's called a durable power of attorney for finances to be able to deal with those individual financial decisions that need to be made that have nothing to do with the trust. And for many of you who have done an estate plan with an attorney, you probably have this and you didn't realize you had it. It's under one of those tabs, okay? But the financial power of attorney needs to be durable. And as I said earlier, durable means it endures incapacity, it remains effective. And it may not necessarily have the title durable power of attorney, but inside it might have words like, this document will not be impacted by subsequent incapacity. You know, it'll be some kind of legalese like that. Why that matters is that a regular power of attorney stops as soon as incapacity occurs. So, for instance, if I were going to Switzerland and I was closing escrow on a house and I needed my agent to sign, my agent could sign under a regular power of attorney. But if I had a stroke before they signed, that regular power of attorney wouldn't work because it's a general. If it's a durable power of attorney, then it works because I'm incapacitated, okay? It's kind of confusing. Don't want to confuse you a whole lot. But the important thing is that you want to be covered so that if you became incapacitated, anything that is in the name of your living trust will be managed by your successor trustee. Anything that is not in your living trust can usually be managed by your agent under the power of attorney. Now, when it comes to IRAs or 401ks or deferred compensation of any kind, we can never transfer those assets into the trust because that's a taxable event. What the IRS says is an IRA has to be owned by a people, has to have a measuring life. So if we were to transfer your IRAs into your trust, it would be the same as cashing them in. So that's why we want to have a power of attorney, durable, to be able to transact business on those IRAs if you become incapacitated. Now, IRAs avoid probate not because they're in the trust, but because you name a beneficiary to your IRAs. So even though they're not in the trust when you die, if you've named beneficiaries, the IRA goes to the people you've named. You just have to be sure that you are covered for all of those things that have nothing to do with the trust, but still need to be acted on in the event of incapacity. I don't know about you, but I'm more afraid of incapacity than I am of dying. If I'm dead, I'm dead. But I really want to be sure that somebody I love and trust is going to be able to be taking care of me, and I don't want to leave it a mess for them. And so you'll want to just look at the title of your assets and see how assets are held. So anything that's in the name of the trust, you know that in the event of incapacity, your successor trustee will manage those. For other decisions, like I'll give you an example of one of the most frustrating areas of using a power of attorney, and that is, if you ever tried to cancel a cell phone for somebody, they won't talk to you unless you've got a power of attorney. Now, the power of attorney stops as soon as you die, and then you've got a different problem. But for during your lifetime, the power of attorney is helpful. Now, one of the questions that was asked earlier is there an expiration date on these documents? And technically, there's not. In practical reality, I can't tell you how many banks tell me her power of attorney is too old. We need a fresh one. And I want to say to them, if I could give you a fresh one, I wouldn't need a power of attorney, okay? So there are kind of two things. Obviously, if somebody did a power of attorney in 2010 and they immediately had a stroke or were diagnosed with Alzheimer's disease, there's no way we can do a new one, but we can show that that's what that person's wishes were then. However, for those of you who remain functional, it's probably not a bad idea to kind of do a new power of attorney every 5 or 7 years. You know, just check it. It isn't an absolute, but for most of you, you'll be changing it anyway, you know. The kid you thought was going to be your agent moved to Texas. Or your daughter got married to a man you don't trust. I mean, there are a lot of reasons for changing. So the durable power of attorney is to manage those things that have nothing to do with the trust. And I'm assuming trust, but many of you may not need trust. So it's just recognize that if all you have is a will is not enough. A will might be helpful if you're dead, okay? But it doesn't help you while you're alive, okay? So you need some mechanism of someone being able to manage things for you while you lack capacity. If you have a will, when you die, your will says who you want to be your executor and where you want things to go. And if your estate is under $208,850 cash or $750,000 real estate, a will may be enough, but you still have to go through certain procedures. And those rules have just changed in the last couple of years. So under most circumstances, I still recommend living trusts as being the best way to move property if you own real estate. The other thing people will say to me is, okay, well, I've named my children, I don't own my home, and I've named my children as payable on death beneficiaries. So when I die, it's going to go to the beneficiaries, my life insurance goes to my beneficiaries, my IRAs go to my beneficiaries. And that works wonderfully when you're dead, okay? But what if you needed some of the monies in your mutual funds that you would name your daughters as powers of payable on death beneficiaries, what if you needed some of those monies to pay for your health care? Do you have a mechanism for someone, your agents, to be able to use those monies? Because your daughters, even though they're named as beneficiaries, you're not dead yet. And what if you have one account that named one daughter as a payable on death beneficiary, and another account that named another daughter as beneficiary, and you needed the money? Which one do you choose to take it from? Okay? Because if you use more money out of one of them, the other daughter is going to say, that's not fair, because you got more money than I did because she didn't use this power of attorney. So that's why I suggest, under most circumstances, and again, it's easy for an attorney to say, okay, I get that, but sometimes payable on death beneficiaries aren't completely foolproof. They may be for your situation. I just want you to think it through. Okay?
Do your agents and trustees have to be local?
Good question. So the question is, do your agents and trustees, do they have to be local? And the answer is no. From a perfection point of view, would it be nice if everybody lived next door and be local? Yeah, it works pretty well. But what matters to me is who knows your heart? Who do you trust? Who would do the best job? Who has the best skill set for this particular job? And it could well be, especially these days, almost none of us have children that all live in the same community. So if geography is a factor, you want to really think it through. How fast can that person get there in case of an emergency? Does FaceTime, Zoom, all of that help? Because in many cases, a lot of things can be managed at a distance without any real issue. So the personality and the skill set of the person you choose is probably more important than geography. From a healthcare point of view, it often is most helpful if your agent is nearby, just so that they can interface with your physicians more often. But I have thousands of clients that don't have local kids. So the important thing is, will they be there for you when the time comes? So talk through the logistics, because another issue will be, okay, you have a daughter in Boston that you want to do the job, but daughter is going to have to fly here several times probably before your administration is over. Should she be able to charge her airfare to the trust? Well, she probably should, because it's a job. But your local son here is saying, you know what? If you'd chosen me, we could have saved the trust a lot of money because you wouldn't have had to pay for airfare. Okay? It's your decision, but think it through. Okay?
If you have accounts that are held individually, not in the trust, and you name a beneficiary, should you name the trust as the beneficiary or individuals as beneficiaries?
Okay, so the question is, if you have an individual account that's not in the name of the trust, could be an IRA, could be just a straight individual account, and should you then name the trust as a beneficiary, or should you name individuals? And it's a very individual answer, okay? By naming the trust as the beneficiary, you're allowing that asset to be used to pay expenses for the trust and make sure that everybody is treated the same as your trust. However, if it's an IRA or a 401k or something like that, sometimes from a tax perspective, it may be easier to name individuals. So I don't want to be too confusing, but it is something that's individual. You just want to really discuss it with your advisors. For the most part, naming the trust is fine. But if you name the trust, I would just ask, why didn't you title the account in the trust instead?
Some banks don't.
Yeah, I understand. Sometimes it's, okay.
I think I understand the durable power of attorney. If you have named a third party as the durable power of attorney and you pass away, who has the authority over the joint checking account that you once shared before passing away?
Okay. So it's a good question. Say you have a joint account and you have a power of attorney. And I've told you that when you die, your power of attorney is no good. Okay, the power of attorney has to be owned by a living human being. So if you die and the person you had a joint account with is already dead, what happens? Well, it depends on the amount in the account. If the amount is under $850, then we have to wait 40 days, and we can usually get at that by a small estate affidavit. If instead, and this is an important point, thank you for bringing it up about joint tenancy. Joint tenancy accounts are accounts that are owned 100% by each of the individuals. So the last one to die wins, okay? When the first person dies, it automatically comes to the other person. And in many cases, that's fine. It's kind of your workable, checking account. But I have some people who say, I'm going to add my daughter as my joint account owner because she's local, and when I die, she'll be sure to share it with the other kids, okay? And she might, okay? But at the moment of your death, that account became hers. So if she shares it with the other children, that's technically a gift from her. For the most part, it's a non-issue, unless you're talking millions. But I want you to kind of think through the ramifications of joint tenancy, because it can really change your estate plan. Think through the ramifications of your beneficiary designations. Because even if your living trust or your will says, I want everything left to my children in equal shares, that only controls what doesn't have a named beneficiary and what's not in joint tenancy. So you can sometimes have a situation where people didn't put their assets into the name of the trust, but named one child as a beneficiary, even though they meant all three of them to have it. And you can really foul it up. So just really think through the ramifications of your beneficiary designations. I'm just a bunch of good news, aren't I? I'm so sorry.
So why wouldn't we just put the checking account into the trust?
Okay, so the question is, why wouldn't you just put the checking account into the trust? And that works beautifully. It's just some people don't like trust on their checks. Okay.
What if you have an account that will not allow you to name your trust as a beneficiary?
Okay. So the question is, what if you have an account that won't allow you to name the trust as the beneficiary? And I suspect you're referring to some credit unions, or occasionally there are those kinds of situations. So I'm assuming that if that account doesn't allow you to name a trust as a beneficiary, they probably don't allow you to name the trust as the owner either. Okay. If they allow you to name the trust as the owner, then that's all you need to do. If not, then You can always move banks, okay? But you know, if your trust is fairly straightforward and it names all 3 kids, then just name the kids as the 3 beneficiaries. But make sure you have an active power of attorney on that account. Okay. So if the account is just in your name alone, and now you're going to add your kids as the beneficiaries, okay, that'll work really well when you're dead. But if that account needed to be accessed while you were alive, and it's just in your name, and now you no longer can understand, then it would be good for you to have a power of attorney, a document with a power of attorney naming an agent to be able to access that account to pay bills and that kind of thing. Okay?
Can either one of the beneficiaries to be the power attorney? If you beneficiary are 2 children, can you choose one to be power attorney or not?
Okay. So the question is, if I have 2 children, can I just choose one of them? Or, you know, it's your life. You may want to choose none of them. Okay? Okay. But the important thing is, you know, this is a really important position. You know, the person who acts as your agent and as your trustee is a fiduciary. Their job is to take care of your money. And so you want to be sure that the person you name is someone you trust. So this is not the time to say, well, my son is the oldest, he's a flake, but he'll be mad because he's the oldest and he's the son. It's not a good enough excuse, okay? But if you are saying, my son will be hurt if I don't name him, but he'd be really better at healthcare than he would be at finances, then I think you should really think through skill sets. The important thing is usually not to name them both together. Okay. If you do name them together, it should probably be in an and/or capacity, because most banks these days will not honor and. They don't like to have to watch for double signatures. But in addition to that, they will, there's just too much potential, I guess, for conflict. So if you can name one and then the other, or you can say in your document, I'm naming him, but I want him to consult with my other children.
I don't have children, so I put my trustee, my niece, I put trustee with my sister.
Yeah.
But my niece is my
Agent?
trustee.
Okay.
And she is my annuities and my personal account, bank accounts beneficiary also.
Right, okay.
And I put 2 beneficiaries, my trustee niece, and in other country, there's my younger sister. So I put 2.
Okay.
And then my trustee can access, after my death, can access my account and my annuities, he can distribute half. Correct?
Okay, so I hope I got everything. It's a situation where what you're saying is you don't have children, but you have a niece instead, which, you know, I've been using kids too much because many of us don't have children, okay? So nieces are fine. It's fine for the niece to be the trustee. The niece can also be the beneficiary. If your trust says that you want your assets split equally between your niece and another person, the niece as trustee must follow those instructions. If instead you have an annuity and your annuity only names your niece as the beneficiary, okay, so if both of them are named, then the company will distribute to both of them individually. What you don't want to expect is naming one person as a beneficiary and saying, please share with the others. Okay.
You also, if you're the person who runs the will, get paid.
Okay. So the question is, can the person who's acting as a fiduciary, whether they're an agent under the power of attorney, a trustee under the trust, the executor under the will, can they get paid? And the answer is yes. And the answer is yes, they should. Okay. Because it's a job. You know, if any of you have ever acted as an executor, you know that you're very glad when the job is done. Okay? It's not fun, it's an honor, but it's a pain. And so it is good for you to allow for compensation. But there are occasionally family members who see it as a job that can now pretty much support them for the next few years. Okay? That's not what it is. But your document should provide that the individual can be paid for a number of reasons. One is, even if your kids are willing to do it for free, what happens if something happens to them and a stranger or another entity has to take over? No bank or private professional is going to act as trustee of a trust that doesn't allow them to be paid. Okay, so it's good to have those provisions. Okay.
Should me and my husband should have a durable power of attorney individually?
Yes, the question is, if I'm married, should my husband and I both have powers of attorney? And the answer is yes. Every individual, frankly, over the age of 18 should have a power of attorney. And you might choose different people. I have people who, especially with health care, in their advance directive, the wife might choose her nieces and her sister, and the husband might choose someone from his side of the family. It's your life. It's who you feel comfortable with, because when this is all said and done, it's about your peace of mind. And I want to be sure that someone I love and trust is in charge. And if that person can't do it, I want to name the next person. Okay, so the question is, can you make a change in your living trust without seeing an attorney? And probably, the answer is probably. And, you know, you would expect an attorney to say that. But if you think about it, this is one of the most important legal documents that you are going to do. So you want to make sure, if you do your own changes, that you read in the trust what makes a change. So sometimes you need to refer to the paragraph that allows for the change to be made. It might say it needs to be witnessed. It might say it needs to be notarized. So the reason I'm just a little bit cautious, without it seeming self-serving from an attorney's point of view, is that sometimes a word or a paragraph can make all the difference. And you can inadvertently make a change that has implications that may be far more reaching than what you intended. So I understand attorneys are expensive, and I understand, you know, you don't want to just make changes for the heck of it. But I also want to make sure that the changes that you want to make are going to be valid. Okay, so if the change that you wish to make can be very simple, can I just write it in? And under most circumstances, my recommendation is you do not want to make notes on your original documents, because that can invalidate. You may be able to say, I want this paragraph, you know, do a formal amendment saying you want this paragraph to be eliminated and replaced with the following, and then sign it in the same way as you signed your original. But it's very individual. The other thing you should be aware of is that most of us as attorneys are covered by malpractice. And my malpractice policy does not allow me to change the documents that have been drafted by another attorney. So I can't just do an amendment of someone else's documents. I have to do what's called a restatement, okay? And the restatement allows you to keep the title of the trust, so you don't have to change the accounts and the deeds and all the rest of it. But the guts of the trust are the language of the attorney. So don't be surprised. This isn't true for every attorney, but many attorneys are covered by malpractice policies that don't allow them to make those amendments. So just don't think we're purposely trying to gouge you, is all I'm saying. Because people will say to me, well, it's only one sentence. And I know, but I can't.
My original attorney has retired, and then I have had an amendment made by a different attorney.
Right. So if your original attorney has retired and another attorney was willing to do the amendment, that's perfectly okay. You know, it's the attorney's problem, okay? And so you may be able to find an attorney who's willing to do it. I just wanted to warn you that it's not uncommon to have to do the restatements. I'm sorry.
I have two questions. Can you hear me?
Yes.
I have two questions. One is that I have made all the arrangements, all my attorney durable and everything. I had a house and I sold it. Should I change anything? It doesn't exist anymore.
Okay.
Do I have to do it?
Okay. So her question is, you know, she did all her legal planning, and at the time she did the planning, she owned a home. And the home has now been sold, okay? Unless your document said, I want my house to go to my sister Annie, there's no need to change, because your house is just part of all the rest of your trust assets. Now, on Schedule A of your trust, where you may have listed the assets, you might want to do a new Schedule A, which you can do without an attorney, just without the trust. Without the house. But just because you've sold an asset, how many of you have changed CDs and mutual funds in the last 15 years? Many of the banks we had don't even exist. So Schedule A at the back of your trust, which usually stated what your assets were at the time you signed the trust, just because just because an asset is on Schedule A, it doesn't mean that it's in the trust. And so I recommend that you just update your Schedule A's from time to time. You don't need an attorney to do that. It's really for the benefit of your trustee, so that when you die or you become incapacitated, they're not looking for First Interstate Bank. Okay? Yep.
The second question is, I'm confused about if I have trust, everything is clear there. Do I still have to mention separate bank and account and the name of my trustee and everything?
Okay. So the question is, if I have a trust, do I have to name all my separate accounts? And the answer is it depends, okay? If your accounts at the bank, title on your bank statement says trustee of your trust, that means your trust is funded, okay? But if you think that Schedule A, that listed all of your assets, means they're in the trust, that won't do it, okay? It'll show your intent, but the title is what really counts. And so if your accounts are in the names of your trust, then the only reason you would list the accounts would be for the benefit of your trustees. Okay.
I have a living trust made about 15 years ago.
Mm-hmm.
I moved from East Coast.
Mm-hmm.
And I would like my living trust by a local
Mhm.
lawyer.
Mhm.
I wonder if I can name the local lawyer, power attorney,
Okay.
and the beneficiary.
Okay. So the question is, I did my living trust on the East Coast. I've moved here, and I would like to have a local attorney, which, no problem, local attorneys would be happy to help. But the next question was, can I have that attorney serve as my trustee or my beneficiary? And I'm not saying it absolutely cannot be done, but there was an attorney here in the early 90s who did write himself into a fair number of wills and trusts. And so the law was passed, so most attorneys, like I will never serve as trustee of my own trusts that I have drafted, and I consider it unethical to be named as a beneficiary. So if you truly want to name your attorney or your loved one or a caregiver or whatever as a beneficiary, the attorney should ask you to have what's called an independent review, so that you go to another attorney to make sure that that attorney was not strong-arming you. So what most attorneys will tell you, and I know this was not true 15 years ago, especially I see a lot of East Coast attorneys, sometimes it's okay practice. Here it's considered kind of frowned on. So here they would probably suggest that you would use a private professional fiduciary. Okay. Okay.
Is it possible to put an IRA account in a trust so it's protected and without paying tax for the transfer?
Okay, so the question is, can I put an IRA into the trust so it's protected without paying tax? And the answer is no. Okay. I understand, I think what you're getting at. It's just the actual transfer into a trust is considered, you're transferring it from you as an individual to a trust, and a trust doesn't have a measuring life. If you are asking instead, can I name my trust as a beneficiary, and can I have provisions in that trust as to how the IRA monies are used, you can do it that way.
Okay, then I have a question. So when the person passed away, if there's still a lot of money left in the IRA, is it instantaneous? You have to pay tax to take it out of IRA, and then the remainder can go into the trust, right?
Okay, so if you have a fairly large IRA and you die, okay, because tax was not paid on the IRA, Uncle Sam is always going to be waiting, okay? If you have a spouse, that IRA can be rolled over, and the minimum distributions are then stretched out over the spouse's lifetime. But any other beneficiary now has to take those IRA funds within 10 years. And so you can no longer stretch the IRA for non-spouses. Yeah, you can stretch it for 10 years. It's just that, and so sometimes people will take more in a year they were low income and less otherwise, but so.
Going back to the living trust and making changes, if you do that, do you need to get it notarized?
Okay, I apologize. Could you repeat that? Could you repeat that?
Going back to the living trust?
Yes.
Making changes, someone over there asked if they can make
Yeah.
changes. Do you recommend that you get them notarized if you make changes?
The question is, if I make changes to my living trust, do I recommend that it be notarized? And under most circumstances, yes. But it will depend. Sometimes the wording of the trust will say, this trust can only be amended if, and it's witnessed or acknowledged or whatever. Occasionally there'll be wording.
Is it okay to use the name of the trustee to name the trust? In case of legal complications,
Uh, Okay, I'm not quite sure that I'm understanding. Okay.
Say Smith, okay, John Smith. Is it okay to say the John Smith Trust, which is the full name of John Smith?
Yes. So what you should say in terms of title would be John Smith, trustee of the John Smith Trust. Okay. Right. The name of the trust is the John Smith Trust, but John Smith is the person who acts on that trust.
What if you become not incapacitated?
Okay, if you became not, in other words, if you resurrected your capacity, okay, then you would just simply need to, it will depend on the wording of the trust, but most of the time you can just prove from a doctor's letter you now can function.
Question, I created our trust decades ago when my child was a minor.
Mhm.
There are all kinds of provisions as to the minor
Yep.
child. Do I need to rewrite my trust because she is no longer a minor?
Okay, so the question is, I did my trust a long time ago when my children were still minors. And there were a lot of provisions because I wanted to make sure, you know, that the money was protected for my child. Now that she has grown up, do I have to change the trust to get rid of all those paragraphs? And the answer is usually not. Usually your trust will say, when she reaches the age of 30, blah, blah, blah. Okay. I want to be able to answer everybody's questions here. Okay.
You'll be talking about how to put your co-op into your trust and to live here, but it's different.
Right. So the question is, what if I have a co-op here in Laguna Woods? How do I get that into the trust? Well, as you know, the co-op is its own animal, okay? It doesn't have a deed like some of you who have condos. So what you will need to do is your attorney will need to write a letter to the management company here indicating that this is how title is to be transferred into the name of your trust. And you then make an appointment with the management company, and they will make sure that the certificate then is changed into the name of your trust. Or if for some reason, if you still owe money, sometimes they can't change it because you've got a lien against it, but they will change the documents at the center, so in the event something happens, it'll still be taken care of. But it does involve a little extra expense. Also, if any of you have caregiver children or special needs children who are living with you and you want them to remain in the community after your death, you'll want to really talk that through with management to make sure that's handled appropriately. You've all been so gracious, and I know this is hard to sit through, and I can go on for a long time. But I think I've covered most of what your concerns are. I do want to just close by talking a little bit about the fact that legacy is more than legal documents and money, but it has a lot to do with things of the heart. And so I would encourage you that if you have special traditions, recipes, photographs, stories, anything that your loved ones would benefit from knowing, you know, really think that through. It's such a loving thing to do for your family. And if you have not read a good book lately, I recommend that you read Joy Span. It's written by Carrie Burnite, who was a gerontologist at UCI. But Joy Span. And it is a wonderful book because what Carrie does is say there's more to life than lifespan. That it's not the quantity of your years, but the quality of your years. And that even though we have to face a lot of challenges in our aging process, some of which are not fun, there are ways in which we approach that process that can make a tremendous amount of difference. And she talks about all of us looking towards growing, being curious about things, of connecting, reaching out to other people, of adapting. Okay, I'm going to need a cane now. I'm going to make that cane as pretty as I can. Okay? And then in the end, when it's all said and done, it's really about how we want to be remembered. And when we talk about all this legalese stuff, I know you're all here because you care. You care about the people in your life. You want to make it easy, and you want to make it easier for yourselves. And so when it's all said and done, by your doing legal planning and you're thinking about all of this ahead of time, you are really going to be adding to your joy span. And I encourage you to encourage each other, because in the end, we all walk this path together. And I thank you for your kindness, your courtesy, and your attention.